Okay, good evening, everyone. So tonight we're going to be discussing the framework for judicial review, and we will have a few discussion questions that we will go over. Now, before we start the discussion of the weekly discussion questions, I wonder if there might be some other questions you might want to raise, particularly about the assessments that we have for the course. Martin Green sent a question in one of the Moodle forums yesterday, and I responded to that question. Perhaps there might be others. I understand. I remember that Tamara Whitaker, if she's around, also sent me a question because some of you seem to be struggling about what the assessment is all about. I mean, I could start discussing it now to provide more guidance, but if somebody wants to ask a question first, in relation to the assessments for the course. And then, you know, in the event that I feel like there are some aspects about the assessment which haven't really been asked at tonight's tutorial, then I will be providing more information about it. Would anyone wish to ask anything about the assessments or anything about the course? And if you wish to, you can always just unmute yourself because I've muted everyone else. Any questions so far? Questions, comments?
Manjo?
Yes, Maria. Hi.
Okay. Hi. Good evening.
Good
There's
evening.
a question on the webpage. Can you who are our intended audience? Because my way of thinking is if we are to have an intended audience, that would change the way we discuss the problem or the central issue. Because say, for example, if it's meant to address a fellow students, then that's okay. But if it's meant to be a non-legal audience, then we'd have to change the way we phrase some words.
Actually, it's intended to be, the audience is meant to be non-legal. And that's the reason why it's a web page, so that we will allow other people, laymen in particular, who may want to learn more about administrative law, to actually access your web pages. So it's meant not to be legal. So the way you present your web page is intended not to come across as something legal. So you're going to have to write it for the audience, which is the broader public, who are meant not to know a lot about administrative law, or not to know anything about it in particular. Would that be sufficient as an answer? Okay. Other questions? Okay, so I'll provide, yes, okay. Who's that?
This is Megan.
Megan, yes.
Hey, I guess a lot of people are trying to figure out just how deep we need to delve into these first couple of assessment pieces.
Yes.
Certainly, like the group that I'm working with, you know, our overall topic, if you like, was immigration. Mm-hmm. And then we drilled down into visa cancellation.
Yes.
And then we drilled down into merits review. Mm-hmm. And sort of that's where we are at the moment. We're there at merits review and we want to dissect that.
Very good.
So do you want to go lower than that? Because what we're thinking is with merits review, like section 501 and the character test and that sort of thing is pretty much the direction that we'll head in.
Okay.
So, yep. Are we on the right track? Is that down low enough for you? Or did you want more specific, like find an actual case and target that?
I'm not really in a position right now to say how low and detailed enough your problem question is, but to me so far, it appears to be sufficient. One thing we need to consider is that in relation to the discussion questions, you actually have a limitation in terms of the word count, which I think is about 500 to 600 words, which includes not just the discussion of the topic itself, but also the discussion questions. So given that word constraint, it already suggests to you that you can't make it overly broad, because otherwise, you know, the type of discussion questions you'd be able to ask will again be too broad. and it will be quite difficult to connect it to a specific weekly topic. So not overly broad and not too specific either. So I think the one you've told me now about visa cancellation and about the aspect about merit review seems to be specific enough. Now, did I hear you say something about the character test? Did you?
Yeah, section 501 in the immigration. So that might come up later, I think, more in the web page.
I would think that is a bit too specific. It's too detailed. So you want to be able to approach, if you're talking about merit review, there is no reason why you need to limit yourself to the issue about the character test. That seems to be too detailed for me, I think, because what would then happen is that you'll be struggling with a specific provision of a statute. But what you want to do is to be able to look at broader administrative law principles and not just a question of about interpreting a specific provision. So I think that might be too detailed. So merit review in relation to an aspect of visa cancellation, that seems to be broad enough.
Excellent, thank you.
So going back to the point I was making, as far as the Moodle group discussion is concerned, both in terms of the Moodle forum as well as the group presentation, you're aware that there is a word count limit, which means therefore that there is a constraint in terms of the way you discuss your questions and in terms of the kind of questions you can ask. So that's one. You will also notice that in relation to the group web page that you're making, it has a higher word count limit, which if I remember correctly, is between 1,000 to 1,200 words. I can't really remember. But the fact that there is a higher word count for the web page, again, tells you that your coverage of a discussion of an administrative law problem is likely to be a bit more comprehensive as compared to the one for the Moodle discussion. That's one. Secondly, so I'm making the distinction now between the two. In relation to the Moodle discussion, your target audience obviously are your peers, your fellow law students. The web page, on the other hand, the audience, as I said, is broader. You're trying to invite laymen who don't have any knowledge about administrative law to try to find out what problem areas there are in administrative law that they may want to learn more about. So the target audience is different. I've also said that there is a difference in terms of the word count. Fourthly, the other difference is that in relation to the web page, there is a requirement that you actually talk about the significance of the problem, which you don't do in relation to the Moodle discussion. So again, you see the differences there. The other difference you can also see is that in relation to the web page, you are invited to actually use videos and images, again, as a way of making your web page more attractive, more engaging to its intended audience, wherever they may be. You don't have that in the Moodle discussion. So the Moodle discussion, therefore, primarily aims to get your fellow students engaged in a topic, in a specific administrative law problem, and get them to think about that problem, come up with their own answers, invite them to think about administrative law rules and regulations as well. On the other hand, the one for the web page, your main purpose is not so much about getting people to come up with an answer, but to get them more informed about how certain administrative problems administrative law problems may actually affect them, and what the law surrounding those particular problems might be. Now, there is a further distinction as well, because you will notice that in terms of the marking criteria for the Moodle discussions are totally, well, not really totally different, but are different from those of the web page. Because as far as the web page is concerned, 30% of your marks will be based on the functionality and the creativity and the aesthetic aspects of your web page. You don't have that for the Moodle discussion. So in other words, you will notice that you are, although you're grappling with almost the same administrative law problem, event, or issue, you are actually being assessed across different dimensions. Okay? So you are being assessed differently in relation to the Moodle discussion, and as far, for example, as the Moodle discussion forums are concerned, you are not only assessed in relation to the kind of questions you're asking, but your ability to respond and engage with your fellow students once they provide their own answers or their comments. In relation to the web page, you don't have that kind of marking criteria. So there are different marking criteria involved. So be aware of them. Now, the way I've designed the assessments, therefore, I'm actually providing students an opportunity to kind of have a progressive understanding and development, of their understanding about administrative law throughout the course. So they begin with just coming up with a problem, and then as they move through the course, they engage with that specific administrative law problem in a more comprehensive and detailed manner. And this approach is different from the way, for example, I used to come up with assessments in the past when I'd come up with legal memorandums in the midterms and a final take-home paper at the end. And I come up with different types of questions, which in the first place are too hypothetical to students and are kind of irrelevant to them. So I'm hoping that given the kind of assessments that I've developed this time, students actually have a choice of the type of topic they want to focus on, especially if there is a specific problem relating to administrative law that they may want to focus on. So that gives a sense of authenticity. But more importantly, there is a progressive development of the understanding about a specific topic. So it's not like, after you've done, a specific assessment, when you move on to the next one, you've kind of left out whatever you struggled with or tried to understand initially. So they are all interrelated, which means that, as I said, I'm hoping that students become more engaged with the topics as a result of this. So was that clear enough? Were there any other questions about the assessments?
Manjo?
Yes. Was that Lauren?
Yeah, sorry. Yeah. Just going on from that, sorry, excuse my silliness, for want of a better word. So just to clarify, I totally get where you're coming from about building on it. So if you could clarify for me, like in the Moodle discussion, it says to provide a factual background of the problem. Sorry, it's okay. In the Moodle discussion, provide a factual background of the problem. In the Zoom presentation, provide a factual background of the problem. In the web page, provide a factual background of the problem.
Yes.
And in the take-home paper, provide a factual background of the problem. So is that kind of, in the sense, we're talking about very similar stuff in that particular criteria?
Yes.
We're just obviously not plagiarizing, like when we get to our take-home paper, we're not going to copy that exact part from the web page and substitute it as our factual background from the problem. We would just, each of those three assessments, with that criteria of provide a factual background, it's all going to be very similar. And then as you say, we build on it, like in the web page. The extra thing is that we're discussing the significance and importance of the problem of issue, which we didn't do in the Zoom discussion. So I can see that's where you're identifying the build-up of the assessment. I just wanted to clarify that, because I think also that might be where Tamara in our group was a little bit confused about.
Now, can I just say something? Can I just say something? Yep. So you're actually correct, Lauren, in your observations, but I want to make a few things clear as well. You will observe a difference between the Moodle discussion as well as the web page, because you're dealing with text, written text. As far as the group presentation is concerned, what obviously happens is there is an oral presentation of the facts. So again, there is a different dimension according to which you are being assessed when it comes to the group discussion, because you're certainly not going to be reading, your factual discussion of the topic or the problem, because that's oral. Okay, so that's one. Now, secondly, as far as the Moodle discussions are concerned, it has to be different. The way that you present the problem in the Moodle discussion will have to be different from the way you present it in the web page, because again, you are dealing with different audiences. So you're going to have to rewrite the problem in such a way that it is attractive to laymen as far as the web page is concerned. So you don't discuss your problem as if it were a legal-based problem. Instead, what you're saying is, you have this person, he's got a problem, what should we be doing? There is a way that we phrase questions in relation to, specific laws assessments. So because of the differences in terms of the audience, you're going to have to rewrite it differently. Now, moving forward to the final assessment, which is the research essay. Again, the research essay has a higher word count. And because, now remember, in the research essay, you are going to be applying the rules to the facts. So there is that major distinction there, because you are not being assessed on your ability to apply the rules to the facts in the prior assessments. And because you will now be assessed according to the application of the rules to the facts, the way that you therefore present your facts is likely going to be a bit different. Not only in terms of the way you presented the facts or the problem in the web page, but a bit different from the initial ones, especially in relation to the Moodle discussion. Because again, as I said, there will be probably fewer details as far as the Moodle discussion is concerned, because you're dealing with lesser word count. Okay, now it's now 6:20. I think I've discussed this enough. Now, if you happen to have any further questions, send me an email, or no, don't send me an email. Post it in the assessment questions forum, and I will address them. And then I'd like to, because now I'd like to discuss the discussion questions. Would you be happy with that? Can we proceed? Okay, good. So I think that should be fine. As I said, you're very much welcome to ask further questions about the assessments. Post them in the forums and I will answer them. But for now, I'd like to spend the rest of the time going through the discussion questions. Okay, so for tonight, after studying this topic, you should be able to discuss and explain the role of administrative law, the relationship between the separation of powers and administrative law, scope of administrative law, principles and values of administrative law, as well as the boundaries of administrative law. Let's begin with the first tutorial question. Okay, so I'm just going to read this so we could go through this quickly. After years of working as a disability support worker, Sharon Hills decided to set up her own business, providing support to disabled persons. The Disability Support Workers Act, Commonwealth, requires that operators, owners, or managers of businesses seeking to provide services to persons with disabilities must have a business license from the Australian Department of Social Services. Such a business license may be given only to persons who have had professional experience as a disability support worker for 5 years and who are of good moral character. The Act also provides that an application for a license must be made not later than 30 June of the same year. Sharon applied for a license on 18 June. However, staff of the ADSS did not accept her application because her documents showing her years of professional experience as a disability support worker were incomplete. She returned on 27 June, Friday, to submit further documents, but these were still considered incomplete, and so her application was not accepted. On 30 June, when she returned with a complete set of documents on her professional experience, she was then asked to provide further evidence relating to her good moral character. She returned the next day, or 1 July, to submit the necessary documents, but the ADSS refused to accept her application because it had been submitted after the deadline. Sharon is frustrated and angry that her application was not accepted and has come to you for legal advice. Assume that recourse to the Administrative Appeals Tribunal is not available. Advise Sharon on whether judicial review is available and why. Now, before we answer this, this is an example of a problem relating to administrative law. Can you imagine how many people are probably in this kind of situation. You know, they ask for something from the government and they get turned down because they fail to submit certain documents. So this is an example of a problem. And as you will notice later on, this specific problem actually has a number of dimensions pertaining to administrative law, which we will see as we answer the problem. Okay. Now, obviously, later on, what will happen is that in relation to aspects of the Moodle discussion or perhaps the web page, you'll probably just be focusing on certain dimensions. Now, I wonder though, as far as the research essay is concerned, the research essay is likely going to be broader because you can't just say that you're focusing your answer to, let's say, natural justice. If I had a problem like this, you're going to be taking up issues about judicial review remedies, and so on. Okay, I won't say much because it's kind of providing the answer. Okay, can I have a volunteer who will try to answer this particular tutorial question? Volunteer. So what are we doing here? When is judicial review available? Volunteer? So as I said, I have observed that there are two ways of dealing with tutorials. A lot of these students, it would seem at CQU, are used to the more directive approach coming from the course coordinator who provides the answers. In my case, I kind of prefer the Socratic method where I try to get students to answer the questions and then I propound further questions just to test the level of understanding of a student. Can I get a volunteer? Okay, Nicholas, perfect. Yes, Nicholas.
All right, we'll open it up. So there's judicial review available if there's been an administrative decision made, if there's issues with the conduct of making a decision, or if a decision hasn't been made. And that's taken that it's not in a prescribed setting where it can't be reviewed.
Okay. Okay. First question I'd like to ask is, when you speak of judicial review, are there at least two ways of looking at judicial review? Because you seem to be focusing on a particular aspect of judicial review when you talked about the fact that there has to be conduct, or the fact that there must be an aggrieved and so on, or it must be based on an enactment. What framework are we looking at as far as judicial review is concerned here?
So that's under the AJDR Act. Okay,
so good. So in relation to what Nicholas was saying, he's actually basing his answer on the Administrative Decisions Judicial Review Act of 1977. Now, I'm citing that because there is another way of asking for judicial review, and that is based on common law judicial review, which we will examine in greater detail later on, which isn't based on the ADJR Act, or we can even speak in terms of Article 75, Section 75 of the Australian Constitution, which is about the power of the High Court to issue writs of mandamus, prohibition, or injunction in relation to decisions of officers of the Commonwealth. Okay, but here, for now, I'm flagging the point that there are various judicial review remedies, and the easiest way of, obviously, is the one based on the ADJR Act, because it provides clear statutory rights on the part of aggrieved citizens to ask for judicial review. Okay, so having cited that, so advise Sharon on whether judicial review is available and why. So was that enough? So in this case, Nicholas, what was it that you said? So would it be available?
Sorry, I'm halfway through dinner. I've got 3 shoots in a row and the cat's pestering me. I would have to ponder it a little bit, because I don't know. I mean, a decision hasn't been made, really. There's no decision, so there's no issue with the conduct. Yeah, so I think it's like, just off the top of my head, I would almost be pushing towards the common law, but
okay,
I'm not certain.
Okay, so that's good. In this case, there is in fact a decision, because obviously she has been turned down. So the decision is to reject her application because the ADSS was unwilling to accept her application because she had tried to submit her documents after the deadline, and therefore, as far as the ADSS is concerned, it is unlikely to accept her application, because the ADSS will continue to claim that Sharon had not submitted her application on time. So that's one. There is a decision. The second aspect is that there must be a ground. Okay, and so we will notice that Section 7 of the ADJR Act provides some of the grounds for judicial review under that particular statute. And one of those grounds, for example, will be a denial on the part of the right of Sharon to natural justice. And we will go into the notion of natural justice in greater detail later on. Suffice it to say that natural justice has two components. One is that every person has the right to be heard. And so therefore, in this particular case, it seems that Sharon was not given the right to be heard because her application was rejected outright, and she was never given an opportunity to try to support her claim that her documents and her application were actually done on time. Secondly, natural justice also pertains to the requirement that the one who's making a decision must do so objectively and act with fairness. So in other words, there can be no room for bias. So that's the second component of natural justice, as we will later on see. Okay, thank you. Any questions on this particular question before we move on to the next one? Thank you, Nicholas. Questions?
Can I put in a quick question? Can you hear me?
Tony, and then we go to Karen. Yes, Tony, go ahead, please. Hello, Tony.
Yeah. Hello. I just wanted to ask, when is an application? Because even though her application was incomplete, did she not put in an application prior to the date and then fill in the gaps later? But could she not say, well, I actually did meet with the requirements and I put in the application earlier? Or is that something that you have to look further into the Act to decide when an application is an application?
Okay. Would anyone wish to respond to Tony's question? Thank you, Tony, before I discuss that. Okay. Now, before I address Tony's question, there is actually a related aspect to the use of the word application. Okay. So here we're looking at the application of Sharon to get a license. There is another way by which we actually use the word application, and that can be an application for judicial review. Okay. In this particular case, let's not get confused. I think the question of Tony related to whether or not Sharon Hills was actually able to actually file an application for a license. So it's not a question of whether or not Sharon has applied for judicial review. So in relation to the question of whether or not Sharon actually applied for a license, it would appear to me that she actually did. And when she tried to apply for a license, the ADSS refused to act on her license for whatever reason. Because one, her application was incomplete, or two, the ADSS felt that she had filed her application out of time. And crucially, the point is a decision has actually been made by the ADSS to reject her application for a license. So given the fact that there is a decision on her application made by the ADSS, the question is, can she apply for judicial review? Can she make an application for judicial review, which is a distinct question altogether? And in relation to that, Nicholas has answered that question and he said, yes, an application for judicial review can actually be made. Now, let me also point out that apart from assuming that recourse were available to the Administrative Appeals Tribunal, and assuming even that an application for judicial review could be made, actually, Sharon could have applied for an internal merits review. So she could have really gone back to the AEDSS and written to the manager, trying to ask for a review of a decision made by one of the staff there. Okay, now I wish to point out again that there is no requirement, for example, that there has to be an exhaustion of the internal review processes of an agency before judicial review can be made. So an applicant, for example, and I'm using the word applicant in the legal sense now. So Sharon, for example, if she feels that it would be unhelpful for her to try to seek an internal merits review because she feels like it may take too long, or she feels that the ADSS has prejudged her case anyway, there's nothing that will prevent her from applying for judicial review. Okay, and so I'm flagging that because I've actually asked this kind of question in an exam, and students got confused in relation to the use of the word application. Okay, clear so far? So we could move on. Thank you, Tony, for your question. Tutorial question 6. The Australian newspaper reported that a federal government commissioned report has detailed widespread and systematic abuses of boat refugees in Australia's refugee facility in Manus Island. Did I pronounce that correctly? The Australian Refugee Consortium, an Australian non-government organization, asked the Minister for Immigration and Border Protection, who commissioned the report, to publish it, but he refused. Doesn't that often happen? I remember, for example, and that's an example of an administrative law problem. A few months ago, there was something about sexual offenses in the Northern Territory, and there was a government report on it, but I think the minister refused to publish it. That, again, is an example of an administrative law problem. That I don't think a court case was ever filed to compel the minister to publish the report. So what I'm saying is there are lots of administrative law problems you could actually focus on, and that is an example of an administrative law problem, because in that case, the minister refused to release the report concerning sexual offenses, or the high level of sexually oriented activities in the Northern Territories pertaining to the I'm not sure about the correct word there. The First Natives of Australia. Okay, because is it okay to use the word Aborigines in Australia? I don't want to be offensive. Is that all right? Do we use the word? That's all right. Okay, I just want to be sure, because so an example is, so what if I end up using the word which is not politically correct, and so therefore somebody complains, and there was this example I think in one university, and as a result somebody files a complaint against me, I lose my job. Could I apply for, is that an administrative law problem? Can you see how, or a student of CQUni Australia was, what's the correct word? Expelled from the university because of suggestions that that student committed plagiarism. Okay, that could be an administrative law problem, actually. In that case, Martin, CQUni is a government university. And so in that case, it is a potential administrative law problem. And you will come across a lot of those cases as we move on through the weeks, that there have been cases involving Australian universities because it is an Australian, so indigenous is the correct word. That's right. Okay. So going back to the question, sorry about that. So I'm just trying to kind of just hammer the point that there are lots of administrative law problems that you can actually examine, including one about immigration or even about the one about boat refugees. Okay, so the consortium has approached you for legal advice on whether it has valid grounds to apply for judicial review of the minister's decision not to publish the report. Give your advice. Can I get a volunteer? Volunteers. Come on. I don't want Nicholas raising his hand again, although I would have welcomed that, but I'd like to get the other students to volunteer. Can somebody just attempt to answer this question? How many students are here tonight? So there are 21 of you. Can I get a volunteer to try to answer this? Volunteers. Oh, Karen, perfect. Oh, actually, is that from earlier? I think Karen raised her hand. Karen, can you try to answer this particular tutorial problem?
I was wondering if they had any standing in order to be able to make an application.
What is it about standing?
Well, they have to have let me just find my notes here. A party's legal standing is required for the court dealing with matters involving individuals with a specific and identifiable right. So that's straight out of the podcast. So whether it's not them specifically that's being affected by the contents of the report. They're not actually one of the people that's reported on in the report. So it depends if they were perhaps interviewed by the commission, which it doesn't sound like it based on the way the question's worded. So do they actually have any right to be able to approach the courts to even start the process?
Very good. So that's one of the critical elements of any application for judicial review. The applicant, and I'm using the word applicant here in a different sense, not the applicant from the first one, when we talked about the ADSS. So an applicant for judicial review must be able to show a legal standing. In other words, that person must have a legal interest. And that legal interest can be a right, it can be an expectation, as we later on see, or it can be a legal interest in the subject matter. And in this case, the consortium doesn't have an interest, doesn't have legal standing. It doesn't have a right. Its rights, none of its rights seem to have been violated or affected. Doesn't have an interest. It doesn't have an expectation. So it does not have a legal standing. And because it doesn't have a legal standing, it can't apply for judicial review. So you will notice, therefore, that as far as applications for judicial review, there are limits to when a court may actually take cognizance of a matter. And the court will only take cognizance from a proper applicant. In that case, a person who has standing based on onus versus Alcoa. Now, there is a second reason, actually, why you should advise that the consortium should not apply for judicial review. What might that be? So that's correct. An application for judicial review is likely to fail because the consortium does not have legal standing. What is the second ground which can be cited that will make an application for judicial review likely to fail? What is that second one? And that can be related to the problem I posed earlier about the decision of the minister not to publish the report concerning sexually related acts in the Northern Territory involving the Indigenous Australians. National security, okay. So when you speak of national security, Grace, there is a broader term for it, which is actually the reason why, so you're quite close to it, which is actually quite which is actually the reason why an application for judicial review is likely to fail. What is that?
Is it the border security?
What was it?
It would be the, I'm sorry, would it be the border security?
Border security?
Border security. Yes, and national security.
Okay, so what?
The Immigration Act? Yeah.
Okay. I'll address that in a short while. So I've taken note of that because that's quite broad. But there is another one. But you're getting close to it. What is it? And I'm going to go back to the issue about border security, because what I took out from what Grace said really relates to the question of whether or not, what if the Commonwealth Parliament passes a law saying that the courts cannot take cognizance of a case involving this specific matter. So in other words, can they oust the jurisdiction of the court to take cognizance of a specific matter? So that was what I took from Grace. So what is it? Okay, there. So from Amanda, and this is the correct one, it is based on political considerations rather than legal standards, making it non-justiciable. So in other words, this is the decision of the minister not to publish the report actually involves a political decision. It is a political consideration. And because it is a political consideration, or it is a political decision, what it actually means is that the courts recognize that certain decisions of the Commonwealth are best left to the representatives of the people, in this case, the elected members of Parliament, or in this case, for example, the Minister for Immigration and Border Protection, who is part of the executive. So certain decisions, if it involves decisions about the Commonwealth, it could be about national security, it could be about decisions about taxes, decisions about welfare. These are political considerations that are best left to elected members of the Commonwealth to decide. And it is not for the courts to second guess decisions, therefore, of elected officials of the government. Okay, so that, in other words, if a decision is really based on political considerations, that's one. The other aspect, as pointed out by Amanda, is that if you deal with political considerations, therefore, you're actually kind of moving away from legal standards. Because if it's a political consideration, how would you define, courts are not permitted to decide issues of legality on the basis of what is right or what is politically correct. It can only be based on what is the law. And so therefore, because it involves a political consideration, not a legal standard or not a legal criterion, courts cannot review these types of decisions. So thank you, Amanda. So in other words, those decisions which involve political considerations are non-justiciable. So they're not for courts to review. Now, the other aspect which I hinted at earlier, which Grace raised, was actually concerning the privative clause, as correctly pointed out by Samantha there. So we will later on come across the concepts of privative clause as opposed to ouster clause. And it should just be sufficient to say that the Commonwealth Parliament cannot oust courts of their inherent jurisdiction. Okay, they cannot. Privative clauses are different because while courts will still have the jurisdiction to rule on the legality of a particular matter, their ability to review such decisions are actually circumscribed. So the Commonwealth Parliament can say that judicial decisions the judicial review can only be made in these specific circumstances. So the ability of the courts to review remains, but the power to review by the courts is more limited based on legislation of the Commonwealth Parliament. And that, in that case, that's called a privative clause. Okay, thank you. So questions, moving on. Okay, the next question. The Stellar Innovations Proprietary Limited won a multi-million-dollar government contract in 2010 to build and maintain certain infrastructure projects as part of the Fast Track Infrastructure Stimulus Act 2010 Commonwealth. However, when Stellar Innovations Proprietary Limited sought to bill the federal government for a portion of the project that had been completed, the Minister for Infrastructure and Regional Development refused payment. The minister asserted that the contractor failed to comply with a key condition of the contract. After the minister refused to reconsider his decision to refuse payment of the contract, Stellar Innovations approached you for legal advice. The contractor wants to know if it can ask for a judicial review of the minister's decision under the Administrative Decisions Judicial Review Act of 1977 Commonwealth. Give your advice. Can I get a volunteer again? Volunteers. What do you think? What advice can you give? Volunteers. So there is a crucial element under the Administrative Decisions Judicial Review Act of 1977, which must be met before somebody can apply for judicial review on the basis of that specific statute. What is that crucial element? And I'm not talking about legal standing. Obviously, it's there, but what is it? Can I get a volunteer? Volunteer. Come on. Okay, I'll just have to give the answer. Okay, so one of the elements that has to be shown by any applicant for judicial review under the ADJR Act is that the administrative decision must be based on an enactment. So in other words, an example of an enactment is a law passed by the Commonwealth Parliament. It could be a regulation as well of the executive. So there's a broad way by which an enactment is defined under the ADJR Act. But the crucial requirement is that the administrative decision must be based on an enactment. In this particular case, the decision to refuse payment is actually not based on the enactment. If you examine it closely, the decision of the minister to refuse payment was not based on an enactment, but because the minister felt that the Stellar Innovations Proprietary Limited breached its obligations under the general laws of contract. So there was a breach of contract. So in other words, the allegation that there was a breach of contract, in that case, the specific law cited is the general law of contract. The minister did not refuse payment on the basis of what is provided under the Fast Track Infrastructure and Stimulus Act, but the minister refused payment on the basis of the general law of contract. So, in other words, for the ADJR Act to apply, the administrative decision must have been made on the basis of an enactment, not under a general law. So you will later on see cases such as the ANU versus Burns, that there will be questions of whether or not the decision, for example, to terminate a university lecturer or a university professor, whether or not it was made on the basis of the law creating the ANU, for example. So the ANU is a government institution. So the question is, was it based on the enacting law, on an enactment, or was it based on something else, which could be a breach of labor laws or a breach of contract? So that has to be, that is a legal issue that will first have to be addressed and surmounted before an application for judicial review can actually be made. Now, I'm just going to twist the question a bit. How would you distinguish? So we've talked here, and this is, I think, being covered here as well, I think. But if you know, in relation to the word enactment, if you were to apply for a merits review with the Administrative Appeals Tribunal. So we have the Administrative Appeals Tribunal Act of 1975, Commonwealth. And there's also a requirement that only certain administrative decisions can actually be reviewed by the AAT. And the AAT Act of 1975 talks of an enactment. Is it in the same sense as this one? If you know what I mean. So when, for example, can a person apply for merits review with the AAT on the basis of an enactment? When is that made? So in relation to an enactment, what does the AAT Act of 1975 provide? If you remember, or if you know. I think it's part of, it's in my notes. Well, anyway, in answer to that, as far as the AAT Act of 1975 is concerned, merits review is actually not available in all cases. So not all administrative decisions are subject to merits review by the AAT. Merits review is available under the AAT Act of 1975 only if a statute, not the AAT Act of 1975 itself, only if a statute provides that recourse can be had to the AAT. So in other words, for a person to apply for merits review under the AAT Act, the specific statute must provide that an application for merits review can be had with the AAT. So it is not the AAT Act itself which would say that merits review is available, but a specific statute will itself say that recourse can be had to the AAT. Okay, now we distinguish that from the ADJR Act of 1977 because in this particular case, as far as this specific statute is concerned, which is the ADJR Act of 1977, it is sufficient that the administrative decision is based on an enactment. So the enactment itself will not provide that judicial review is actually available, regardless of whether or not, in fact, the law will not say it. So even if an enactment will not state that judicial review is available, under the ADJR Act, it will be available, or under common law judicial review will be available if a decision is based on an enactment. If an administrative decision is based on an enactment. Clear? Questions? None? Okay, let's move on. Okay, now where do we go? This is a very long question. Has anyone read this question? It's quite long. Is it possible for me to skip reading the question and we just try to answer that question, because we've only got 5 minutes to go. I've got a class at 7:15. It'll probably take me 3 minutes at least to read this. Can somebody attempt to answer this particular question? So it's a long one. I'm hoping that you've had a chance to actually go through the discussion question in Moodle. Any attempt? Can anyone attempt to answer this particular question? Anyone? Okay, so the point really here, the legal issue really here, pertains to whether or not there is a final and determinative and substantive decision on the request on the part of Makepeace for the government to allow it to import certain books. That is the question. So far, it would seem that the staff, certain staff of the government, have kind of said that we are not yet prepared to make a decision on this. Okay, so what they've said is, they're making progress, but obviously, as far as the government is concerned, they have not turned down the request of Makepeace. Okay, and because the government has not yet turned down the request of Makepeace to import certain books, the question then is there a final and determinative and substantive decision? Because if there is none, then recourse cannot be made to the ADJR Act of 1977. So in the case of Australian Broadcasting Tribunal versus Bond, the High Court has ruled that the ADJR Act, an application for judicial review under the ADJR Act, can only be available if there is a decision which is final and determinative and substantive. In this case, you can't speak of a final and determinative decision because the government has, in fact, yet to make a decision on the subject. Now, the reason for this is that what the courts hope to avoid would be piecemeal judicial review applications. So imagine if every single preliminary decision made by the executive can then be subject of judicial review. That will clog the dockets of the courts. Okay, so the courts have said that as far as the ADJR Act is concerned, it will only review administrative decisions if those administrative decisions are final and determinative and substantive. Okay, I won't talk about substantive because that's the next question there. Questions so far on this? None? Okay, good. Let's move on to the final question. In Australian Broadcasting Tribunal versus Bond, which I cited earlier, the High Court ruled at the conclusion of the Australian Broadcasting Tribunal that Mr. Bond was not a fit and proper person to hold a proper license, was not a reviewable decision under the ADJR Act. The High Court made that ruling even if the ABT conclusion on Mr. Bond's fitness was determinative of the ABT's other conclusion that licensee companies under Mr. Bond's control were consequently not fit and proper persons to hold commercial broadcasting licenses. How did the High Court arrive at its ruling that the ABT's conclusion that Mr. Bond was not a fit and proper person to hold a proper license was not a reviewable decision under the ADJR Act? It would appear offhand that there was a final and determinative decision. After all, so under the law, in this particular case, for those who may have not read the case yet, so Mr. Bond owns certain broadcasting companies, and the requirement is that before a license can be given to a broadcasting company, there must be a requirement about the fitness of its owners as well. Because obviously, the owners or the persons who control a broadcasting tribunal can exert a very high level of control over their broadcasting stations or companies. And so there was a requirement that not only, there was also a requirement, therefore, that those who are in control of broadcasting companies must be fit and proper persons in this particular case. Therefore, there was a finding that Mr. Bond was not a fit and proper person, which could have an effect, therefore, on the broadcasting license to be given to one of the companies that was owned by Mr. Bond. So the question is, how did the High Court arrive at its ruling that the ABT's conclusion that Mr. Bond was not a fit and proper person to hold a license was not a reviewable decision under the ADJR Act? What do you think? Okay, so no answer so far? Okay, we're just gonna go through this quickly because it's 7:01. The reason for this is that when you look at the power of the Australian Broadcasting Tribunal, it was actually within the power of the Australian Broadcasting Tribunal to determine whether or not to grant a license to a broadcasting company. Okay, Now, the mere fact that Mr. Bond was deemed not to be a fit and proper person, although that could influence ultimately the decision of the ABT to grant a license to a broadcasting company owned by Mr. Bond or not, the fact remains that the ABT had not yet made a decision on whether or not the owners of that broadcasting company were actually fit and proper persons. No ruling had yet been made. It was only a preliminary matter in relation to Mr. Bond. So at some point, the ABT could decide to grant the license to the broadcasting company anyway. Okay, so because of that, therefore, there was no final and determinative decision. And because there was no final and determinative decision, the High Court ruled that this was not a reviewable decision under the ADJR Act. Okay. Questions before we end tonight's session? So we're good? Okay. So thank you everyone for joining tonight's session. If you have any other questions about tonight's session or about the assessments, feel free to post them in one of the discussion forums and I'll answer them as soon as I could. Okay, and thank you everyone for tonight's session, particularly to Tony, to Karen, and to Nicholas and Grace as well for engaging in tonight's session. Thank you everyone. Good night. See you next week. Bye.